Need to unmute the microphone there. But welcome to episode 70 of the No State Project, live commercial free from my YouTube channel, No State Project. We're live every Wednesday from 3 to 4 Pacific Standard Time. And also, we get another 3 hours of Anarchy Radio every Saturday. It's 1 to 4 Pacific Standard Time. So whatever we don't get to today, we will get to on the Saturday broadcast, which is also broadcast right here on my streamed live on my YouTube channel. You want to join the big show today? It's 218-632-9399. 218-632-9399 is the number to get in to the queue and get you up on the big show. And, you know, I have to go through, and it's Frank Rizzo 3 also. If you are using that there Skype, don't instant message me first. Don't just call the show, and then we'll get you on the broadcast. I want to, again, thanks for their continued support of the show, the No State Project. Bill and Dan in New Hampshire, I can't thank you guys enough. I do appreciate it. So this show and last show was brought to you, of course, by Bill and Dan. And if you'd like to support the show in some small way, you can do it at markstevens.net. And I know I haven't gotten to the success stories, but given the overall lack of views, the fact that those videos tend to get very, very poor reception, I'm probably not going to do a video. I'll probably just load and do an article at markstevens.net instead of taking the time to do a video and load that up. Apparently, we've got enough evidence on video wise. At this point, it's just kind of overkill. It's not, and it wasn't even supposed to be a big part of the show. The show is about getting to a voluntary society, not just posting about having success in court. So yes, definitely aloha, Stephen and Anonymous there. Appreciate everyone tuning into the big show. If you missed a live broadcast because you're not subbed or if something else is going on, get the audio after the show at markstevens.net. And so something I got to get to, actually, we've got callers, so let me just be brief in saying this then, because it is very repetitive, and I get that. But we got a lot of new people that are tuning into the show. A lot of people, tuning in to learn how to effectively defend themselves. And so anyone can go to markstevens.net, and you can see that we've replicated the success many, many, many times over. So the fact that I don't post everything at this point, not really a big deal. But I have to keep reiterating that I have never said, and I don't think anyone has ever called this show and said that going to court is a walk in the park. It is very frustrating. You're dealing with criminals who think they're honorable. The risk of going to jail is always present. We talk about that all the time. I said the principles are very easy to understand. If you understand the basic principles of the Socratic method, and that we're just keeping the burden of proof on the accuser, and that we are going in with the mindset that everything coming out of the prosecutor or the judge's mouth is a lie, and that we're going to challenge them on it, you don't need to have me or anyone else spoon feed you exactly what needs to be said. So I know that there was somebody that was very upset, saying he had to go to court, had no idea what to say. I have a book called Government Indicted, which I go through all the detail regarding that, how we ask leading questions. I even have a script that I say every single show. That's twice a week. 4 hours of Anarchy Radio, where I'm always telling people, get the script, get the motion to dismiss, go onto the website. Everything else is there for free if you can't pay a few bucks for it, for really just the format. But you've got to also make sure you do your role playing. You can't wait until 3 hours, as someone did last week, 3 hours before going to court and contact me. You can give me 10 grand, which would be cool. I can't accept it under those circumstances, but you have to prep. Going into court, again, the principles are easy, but you still have to prep to be able to be effective to go into court. You're dealing with professional litigators, guys who are in court every day. Yeah, 95% of all criminal complaints, or maybe all complaints, period, wind up with a deal. But that doesn't mean that prosecutors are not professional litigators. They're in there every day. So that may not have a trial every day or even every week. But these guys spend their life in the court. They are litigating to some degree. And yes, they are doing trial prep and they are doing actual trials in front of juries. So you have to do some work. I'm not saying it takes 1,000 hours worth of work, but you have to do the work. So you can't just piss your time away and think that you could just file a motion and then expect that they're just going to grant it every time, because they don't. And you don't have to prepare to go to court. These people are very shrewd. They're not stupid, and to underestimate the how smart and effective that your enemy is a really bad way to start. So you've got to prepare. If you don't have a script, fine. You can still do the role playing. You can, and look, and if you can't do the role playing on Skype, you can call the show. 4 hours a week I do this broadcast, and I'm more than happy to go through with somebody on a show, sometimes even after the show, so that we can help get you prepped better for court. But don't let anyone kid you. I know we've had a lot of this stupid common law stuff coming up recently that, just do this, that, just sign this and accept it for value and you're good to go. It doesn't work that way. You have to be prepared. You have to do the role playing. That's why I say on the show, go to a city council meeting so that you can confront a city council, so that you can get your teeth cut. You can get your feet wet. So you're not just going in cold. So you don't have to freak out and email me or somebody else that I'm an a-hole because you don't know what to do. There's a responsibility here. Whether you're doing it as an activist, you're doing it on principle, or you just need to limit the damage that these animals are trying to do to you. You have to put the work in. It's like, Mark, give me the basics on boxing, and because I got a fight coming up. All right, here, this is what you do. You're going to have to spar and then freak out the morning of trial or your fight. Well, I haven't sparred. I don't know what to do. I kind of have an idea what kind of punches to throw and whatnot, and how to move my feet and the jab, but you got to put the damn work in. These people are professional criminals, and they just love when you come in unprepared. So put the damn work in. We've got years worth of replicated success stories on markstevens.net that other people who have gone through and have spent a few hours, a number of hours preparing, have done very well. So please don't take it light. Going into court is you run the risk of not walking out again. That whether it's it doesn't matter what it is. You don't even have to be charged. The fact that you walked into a courtroom, the judge has the power to put you in jail indefinitely for contempt. So please take it serious. You have to prep. And again, if you're one of these people, if you're horrible at public speaking, or you just can't dedicate the time, then just pay it. Just pay it. Throw your hands up real early and just chalk this one up to your schedule. But if you're going to do it and you're going to challenge them, you damn well, you have to put the time in. You have to put some time in every day, even if it's a half hour to 1 hour, every day for a few weeks, preparing. Go to at least one city council meeting. I tell you right now, you go to a city council meeting and you start asking questions and you're not prepared, you'll know right away. You probably won't even have to get up there yet. And you realize that if you're so stressed out and nervous, then you know you're not even close to being ready to be able to go into court where the stakes are much, much higher. So please keep that in mind. And the tactic is very easy. We are holding the burden, the accuser to their burden of proof and assuming that every single thing that comes out of their mouth is a lie. And we're going to object, and we're going to ask them leading questions to bring out that it is a lie, so that they can either confirm what they're saying is true, or it's going to come out that they have no support, that they're speculating, and they know they're speculating. And they may not even give a damn, but at least you'll be able to use that against them. So you have to put the time in order to effectively defend yourself. So don't let anyone kid you that going into court is easy. The tactic is easy to understand. It's not easy to put it into practice. Okay? So let's, without further ado over here, why don't we get to the phones? Looks like we got a new caller. I think it's Nebraska. We got area code 407. You're live on the No State Project. What's your name? Where you calling from?
My name's John. I'm calling from Orlando, Florida.
Okay, Orlando. What do you got for us today, John?
Well, I got court on the 19th. I was doing, allegedly, 79 and a 45, so it's mandatory court. They pulled me out of the car, took my gun, the whole nine, cuffed me, all that fun stuff. And so I went on YouTube and watched, what was it? Arraignment Foundations, all 80 videos. So I've been taking notes and prepping and everything. And my question is this: should I submit the motion to dismiss before I go to court, or should I save that for after they steamroll me and push me through to a trial?
I always recommend filing the motion to dismiss as soon as possible. Don't wait. There's no need to wait. And you file that with the discovery request. And so some people say, well, what about the element of surprise? If your opponent has no evidence to support their claim, you don't need the element of surprise. It's in fact, I think we get some leverage on them, and that's why we get so many dismissals, because they know in advance that you're going to be pushing, on their Achilles heel. And the best they can do is lie and say that jurisdiction is a trial issue, or come out and say, well, John, we're honorable. We're lawyers, we're prosecutors, we're the state. We get to argue without evidence. So that, so that's why I file it as soon as I can.
Now, I'm probably going to order the motion to dismiss off your website. Will that come with the unsigned plea of guilty?
It does. It comes with the discovery request. It comes with the unsigned plea of guilty. I include in all the instructions, and I also have the motion in limine, which, for those who aren't aware, a motion in limine is a pretrial motion to limit argument or the omission of evidence for various reasons. So we filed a motion in limine against the prosecutor so that they cannot argue without evidence or a witness with personal firsthand knowledge.
Right. Yeah, the first words out of my mouth when the cop came up to the window was, "What facts and evidence are you relying on to make the legal determination that the codes and laws apply to me?" And he's like, "License and registration."
Well,
like,
John, come on.
I was like, "Can those be used against me in a court of law?" And he goes, "License and registration." And I said, "Why would I want to help you rob me today?" And he's, "Are you refusing?" I said, "No, I'm not refusing. I'm just asking you a question." And he goes, "If you don't give me your driver's license and registration, I'm going to take you to jail." I said, "Well, under duress and threat of violence, I will comply, only because I don't want to be assaulted and go to jail today." So, and then I told him, "No, I don't consent to search and seizure." And I did give him my concealed weapons permit because I didn't want him to realize that I was armed after he had gone back to his car and come back with his gun drawn.
Well, the important thing here is, are you of white European descent?
Oh, absolutely.
Yeah, if you were of African descent or Mexican descent, even with a concealed carry permit, that's when your life is in danger. Cops typically don't shoot armed white people under those circumstances.
Well, the stats are actually even on that, from what I understand, according to the FBI stats, that they shoot just as many white people as they do people of color. So
armed white people.
But I just didn't want it. I didn't want him to be surprised.
Right. Well,
and and after he took my gun, then he put me in cuffs, and I'm like, why are you putting me in cuffs? You just disarmed me. Yeah, I'm no threat to you. Not that I was a threat before with the gun. I mean, there's 3 guys with Glocks with 15 rounds each, and I got my little 380 with 7 rounds.
Yeah, but John,
I'm not suicidal.
Well, no. Well, there's that's another. What I want to get to here is, why are you asking the cop questions? You should not be speaking to this guy. You could be labeled now a sovereign citizen or a freeman. And a domestic terrorist.
He goes, while the one cop was writing the ticket, I was berating the other 2 cops. I was like, how long you been members of the Blue ISIS, the most feared terrorist organization in the United States? I said, you're an effing criminal. You're,
wow.
You destroy people's lives. I mean, I was just berating the other 2 cops. I'm like, do you even know the definition of driver, or the definition of, motor vehicle or transportation? I mean, you don't even know the definition of the words, and you enforce laws that are based on these things. I mean, I was just berating them for like 10 minutes while just because I was kind of upset because they, assaulted me and put me in cuffs.
Okay, you're upset, but you do realize, and I want other people listening to know that I think the best thing in these situations, because you cannot talk your way out of a ticket. You shouldn't even try. Everything you say.
No, I wasn't trying to talk my way out of the ticket. Okay. I was just trying to.
I'm talking in general,
point out the fact that they're criminals.
I'm talking, but the thing is, on the side of the street is not the place to do that. If you want to do something like that,
I get that now.
Yeah, but
in the heat of the moment,
but I'm
it's
talking
a little different,
Yeah, well, exactly. I understand, but I'm talking to people who are listening and will listen to the podcast, so that they know not to do that. If you're stopped by one of these 5-year-olds with a badge and a gun, okay, that's the emotional level of a police officer, and I defy anyone to tell me and show me evidence to the contrary. That's in a general. Most of them behave that way. You want to keep your mouth shut. It's all under threat, duress, and coercion, whether he tells you he's going to arrest you or not. We know they have a force continuum. We know that once the lights go on, that's the first part of the force continuum. We know it's all under threat, duress, and coercion. We know if we don't stop our car, they're going to go through the force continuum, and they're going to use their car to ram us. Then they're going to run out of the car with their gun pointed at our head, screaming, okay, like a berserker, and we don't want that. So just keep that in mind.
Right.
You don't need them to say, I'm going to take you to jail. It's already, the facts are very clear. It's under threat, duress, court. So everybody listening, cop pulls you over. Don't answer any of his questions. The only thing you should say is, on advice of counsel, I am not answering your questions. Keep your mouth shut from that point forward. Give the license and registration. It's under threat, duress, and coercion. It couldn't possibly prove their constitution applies to you because they're forcing you to ID yourself. So don't worry about that. So, and all those things
when I refused to sign the ticket, he goes, well, if you don't sign the ticket, I'm taking you to jail right now. And I said, well, under the threat of violence and under duress, I'll sign the ticket, but I am going to write on the ticket under duress. And I did. I wrote UD and then my signature. So
sure. Now, the other things that you were talking about, it always makes me cringe because look, you do not want to challenge these people on their definitions. Okay. Don't waive jurisdiction, okay, by and just negating your challenge there by discussing what the laws say until they first prove that their constitution applies to you. Because relevance is key here. So for everyone listening, nothing matters in court. I mean, nothing matters if you cannot show relevance. Nothing. So you can have, so hypothetically, you can have a video of the police officer planting evidence on you. If you cannot show relevance, again, I'm just giving you an example. It doesn't mean it's completely accurate. But if you cannot show relevance, it doesn't matter. So it's the same thing here. We're not going to discuss something that's not relevant before it's been shown to be relevant. So don't skip step 1, which is jurisdiction. Yeah. Don't skip that. And I'll tell you right now, if you start arguing definitions, you're going to lose. I mean, I had someone do this a few days ago, and I looked up the definition while we were on the phone. I'm like, it doesn't say that. Yeah, but I think it It doesn't matter what you think. It only matters what you can prove. And if you're just going based off a definition, if the definition says ABC and you think it says XYZ, well, guess what? Who's going to, that's a really bad look. Your burden of proof on an interpretation of the law is extremely high. Don't do that. You want your challenges to be factual.
Well, I had no intention of bringing up the definitions at court. I was just making an example that here you are enforcing laws that you don't even know the definitions of.
But wouldn't it be better if you're going
as part of my berating them while I was waiting for the other cop to write the ticket?
Well, you shouldn't be berating them because they could wind up killing you. Two, if you are not in that situation and you want to discuss these things, it's much better to walk them through the Socratic method and say, oh, you believe that you have jurisdiction over me? Why? Because you see me physically here in Florida, and that means that your laws apply and give you jurisdiction over me? They'll say, yeah. Well, now all you have to do, and this to me is a far more effective way to actually berate them. If you want them to feel stupid, if you want them to feel small, they say, really, why do you think that's true, sir? What evidence do you rely on to prove that just because I'm physically in Florida, that your laws apply to me?
Well, they go, well, the legislation gives us the authority and blah, blah, blah. And I'm like, because the one guy, he did go, what are you, a sovereign or something? And I said, a sovereign, what's that? The only sovereign I know is God.
Oh, well, let's not.
What's a sovereign?
Hold on. Well, you see, you whenever you're dealing with these people there, John, especially when you're going into court, because you weren't in court, so you could ask them questions, say, what makes, why do you, what evidence do you have to prove this claim? Right. But you don't want to get into making any statements. We're just going through the mistakes that you made, what we don't want to see you do if it goes to court, if it actually goes to trial. Everything that you should be doing is holding them to their burden of proof. You say something about God, I mean, now they don't give a damn, and then now that puts an onus. The burden is now on you. Oh, God's a sovereign, and the evidence you rely on to prove that, sir?
No, like I said, none of this stuff that I said to the cops am I going to say in court, other than what facts and evidence are you relying on to make the legal determination that the codes and laws apply to me.
There you go. That's
the only thing. I'm going to stand on that, and I'm not going to move.
Yeah, and the witnesses with personal knowledge of that.
Right. Well, the fact of the matter is, you're going to raise your hand and swear to God to tell the truth, and how can you lie and plead to a case that is invalid? That would be a lie. So I will not bend. I will not back down. I will just stand firm on what facts and evidence are you relying on to make the legal determination that the codes and statutes apply to me.
Yeah. Well, you have no business swearing in, period, on this. You should not be swearing in or testifying in any shape or form.
Well, typically, don't they have everybody raise their hand when you all come into court? It's been a while since I've been there, but is that only a trial, or do they do that at arraignment too? Usually?
That should only be a trial for witnesses. Now they try to pull that crap where they try to get everyone to swear in, but the prosecutor's not swearing in. Only the witnesses are swearing in, and you tell them objection.
Because every word out of his mouth is a lie. He can't swear to tell the truth.
Well, but the thing is, it's up to you to ask leading questions to bring out that they are a lie. We have to prove that.
Right.
That we have to. I'm not saying that every single word or every sentence the cop, or prosecutor, or judge say is actually a lie. What I'm saying is, as a tactic to keep you on your toes, so you don't let anything go by, you object to everything as if it is a lie, so that they have to stay and keep to their burden of proof and actually prove everything. That's what I mean by that. It's not that. Yeah. Right. I mean, yeah, we have the joke that even if a politician. If a politician told me what time it is, I'd still double check it. Not everything they say is a lie, but we have to assume in these situations so that nothing gets by us. And the big thing that gets by people is they allow the basic foundation of the prosecution's case on personal and subject matter jurisdiction. They just assume that that's true, or they just accept the lies that are given to them. Where so you might hear that jurisdiction is a trial issue. It is a trial issue, like I've said 1,000 times. It's not a trial issue only. So that's something that they're going
Right.
to. So what you also need to do is you need to get the discovery request in with the motion to dismiss.
Now, I had kind of planned on an opening statement kind of thing, like, is this a court of record? Yes. For the record, I'm not here on my own free will. I'm here under duress and threat of violence, because if I didn't show up today, men with guns would come assault, kidnap and imprison me. And if I was to resist, they would tase me. And if I resisted further, they would possibly shoot me. So the only reason I'm here is to get that threat of violence removed from my life as soon as possible. I have an unsigned plea of guilty. My intention is to sign this today. As soon as I can get clarification as to the nature and cause of the charges, do I have the right to a fair and meaningful hearing here today?
Well,
what you're saying.
Well, it's way too long. You have to. You want to be terse. Somebody who is a good friend of mine helped. He was a professional editor with NASA, and so he was the one. You got to be terse. You got to be terse. It's one thing when we're talking about it on the show, but when you're in there, you have very limited time, and they're going to have very little patience. So you want to get to it as quickly as possible. What you want to keep in mind here is if you're going in there, you should have the motion to dismiss. So when they're asking if you're ready to proceed, I would object and say we have a motion pending that needs to be heard first. Has the prosecution met their burden?
Right. Just go straight for the burden of proof, or the facts and evidence that the law applies, instead of going through the 5 softball questions before, to get to the hardball questions.
You may not the thing is, I always go in now with the assumption that I don't have the time, so I'm going to go right for the throat. So I only get to the unsigned plea of guilty if they just say fangul and they deny it without an explanation, or they say that they're going to wait till trial to hear that, or wait until pretrial. They'll schedule a hearing on that, and they absolutely want you to just enter a plea. Sir, all we're here to do is enter a plea. Then I go in and tersely, very succinct, and I say, I intend on pleading guilty here today. And you have a copy of the unsigned plea of guilty. You've got that written. You give a copy. And you go and you don't ask if you can. You just ask the question. You don't ask permission. You just ask. Has the prosecution met their burden on personal and subject matter jurisdiction? Is there sufficient evidence
to satisfy the element of jurisdiction?
You got personal jurisdiction and subject matter jurisdiction.
Right. Well, if you just say element of jurisdiction, it pretty much covers both, correct?
Yeah, you could just say jurisdiction. You don't have to say that. But if you're lucky enough to get into a discussion on it, then you can break it down. You got to show personal jurisdiction, which unfortunately can be waived, but it's not waived by filing a motion to dismiss. That's not it's not the same. But do you know the difference between personal jurisdiction and subject matter jurisdiction?
Go ahead and refresh my memory.
Personal jurisdiction is the court's authority to act on you, to force you to participate in the proceedings and defend yourself.
Okay.
Subject matter jurisdiction is that they have power to hear certain types of cases. So here, let's say it's a traffic. They've been given jurisdiction through the Constitution and law and yes, all jurisdiction is from the Constitution, or it's unconstitutional. They have jurisdiction or power to hear and adjudicate justiciable cases or controversies regarding traffic matters before them. Now, subject matter jurisdiction and personal jurisdiction, or in personam jurisdiction, the basis is from the same thing. It's from the Constitution. Personal jurisdiction is that if you're physically in Florida, the Constitution applies and gives the court jurisdiction to act on you. Subject matter jurisdiction is the same thing, because to have a traffic case or controversy, there has to be the violation of a legal right and damage, or you have to have a legal injury. Now here with you, they're claiming that the legal injury is the violation of their laws. Well, that has to be shown to actually apply in the first place. And
right.
So that's where the two tie in together. And so some may say that with subject personal jurisdiction, you're just being there. I mean, you heard that we're just physically being here, the laws apply to you. Does that sound?
when I said my open, I wasn't reading it. I was just doing it from memory. And there was part I left out was, in no way can my presence here be construed as through silent judicial notice as my consent to the jurisdiction of this court. I was supposed to say that in the opening.
Yeah, but that's a statement, John.
Like you said, I probably won't even get a chance to do the open anyway.
But the thing is,
I was going to include that.
But that's a statement. See, the difference is a statement they can just ignore you and just say whatever. Yeah, well, we disagree with you. What you want to do is you want to just make objections and ask questions, and keep the burden on the prosecutor where it belongs. And here, the prosecutor bears the burden on personal and subject matter jurisdiction. There's no way that you can. There's no way that you can prove the laws were violated until you first prove that they apply.
That they apply.
And
yeah, exactly.
So the idea, though, John, that we can prove the laws apply by proving you violated them. But if you're assuming they apply to prove that I violated,
circular logic.
Yeah, it is. I've had plenty of prosecutors that I put on the spot. These were people who were actually attacking people I was working with, and asked them point blank, exactly how would you do that? How do you prove that the laws were violate, that the laws apply by proving you violated it? I mean, just explain to me how you do that without assuming that your premise is already true.
Right.
And none of them can actually tell me.
It's like saying the Bible's true because the Bible says the Bible's true.
Yeah, you're assuming that your premise is true, and that's your starting point, and that is circular logic, or begging the question is another. That's why you'll have some people say, well, you can't use basic principles of logic in law because law is irrational. It's a different type of logic. Well, that's. If we're showing that the system and the proceedings against us are grossly unfair and fundamentally unfair and violate traditional notions of fair play and substantial justice, well, then we can do that by showing that it's illogical. To me, I think I'm better off showing that it's gibberish as opposed and illogical than trying to shoehorn in and say, well, it's legalistic gibberish. It's like what the IRS does to you, John. They turn around and they say, if you have a trust, then they say, or any kind of entity, and they say, oh, well, the entity, the trust is a sham. And then they haul you into court and they say, you can't represent the trust. You have to have a lawyer. Wait a minute. You said the trust was a sham. Oh, we only meant for tax purposes. It's a legitimate organization for any other purpose, but for taxes, it's a complete sham. Like, oh, come on. This is what you got to expect. And that's the thing. This is why we practice, so you can recognize when they're being illogical, because that's unfair. And they could try to paint it with whatever brush they want and say, but in our world, it is fair. You're a crook. You're a friggin' crook. If you think A is B in your world, that's dishonest. And if you look at their own ethical rules, John, their own ethical rules say, I know it's more of a joke. Their own ethical rules say that they cannot argue without fact and law. Their own basic principles in law, that the burden of proof is on the prosecution. The one who makes the burden, who makes the accusation, bears the burden of proof. We already know that nothing comes into court and can be considered unless it's relevant. And where does relevance come from? Basic logic. So,
yeah. Well, this traffic thing is my preparation for the tax issue that's going to happen here sometime in the near future.
Well, I'm sorry to hear about that, but what I got to get on to some other callers. What I would recommend, get the do the motion to dismiss and the discovery request. I even put in the instructions of calling the prosecutor. Don't talk about the merits. You just want to know, did you get this? And by the way, what evidence do you rely on to prove this? Whatever, and what's the name of the witness or personal firsthand knowledge?
Right.
And remember.
All right. Well, I appreciate your time.
Not a problem. Keep in touch and good luck. Make sure you role play. And don't be afraid of asking the prosecutor outside of court what evidence he has to prove their claim the laws apply. You're not in court, and he has to prove every element beyond a reasonable doubt to the judge's satisfaction, who has the ultimate decision there. And again, when you're on the side of the street, people, the idea of berating 5-year-olds with guns, not a smart thing to do. So hopefully we never have to hear a phone call again, at least not somebody who's ever heard the show, where they felt the need to berate the cops on the side of the street. So let's not have that. Another caller, new caller. We have area code 754. What's your name? Where you calling from? What?
Hey, what's up, Mark?
Hey, how you doing? I'm glad that that background noise stopped. What's your name? Where you calling from?
Oh, this is another John from South Florida.
Okay.
But I was just calling to listen in because I didn't see the stream on the YouTube. I don't have any cases. I'm just absorbing knowledge, watching all your videos. You're awesome, man. I'm glad I found you. Your concept is so simple. And I know it's not, like you said at the beginning, I know it's not foolproof. It's not easy. You're going to be challenged, but so confident, like just learning this material. Even when I drive now, I'm not scared anymore. But I don't have anything going on. I'm just prepping for what could potentially happen in the future.
Okay. So you had no questions?
Yeah.
Now that you got me, but you didn't have any questions?
Man, I'm happy I'm talking to you, but like the only thing I have to do is get the script and learn it. And basically, just by listening, like a lot of the stuff you just told to the previous caller, like how do I handle getting pulled over? Because a lot of us have been listening. What brought us to you is all that Freeman sovereignty stuff. And it's good to know because, everybody's trying to get rid of their driver's license, get rid of the plates. And that's kind of the path I was headed down. But like now, I know better.
Well, I'm glad to hear that and that you're ditching the Freeman stuff. I'm still stunned that I'll hear from somebody who actually got the motion to dismiss and the discovery request, and they'll put that Freeman stuff in also. So we don't want to see that. Yeah, getting rid of the plates, especially in a place like Florida or California and New York. I did that myself, which is what led me down this road. I was a much younger guy and I wanted to try it out. I mean, that's where I cut my teeth on court. That's where when I got in there and started realizing, they don't care about the law. They don't give a damn. I mean, I've mentioned, Brian Strong, this prick, he stared down at me after all I did was read directly the ruling, not dicta. I read the ruling in Brown versus Texas that it is a violation of the Fourth Amendment, illegal to arrest somebody simply to ascertain their identity. And he snapped at me, says, "That's your interpretation." I'm like, what the hell are you talking about? Interpretation? I just read it directly to you. What do you think it means? Yeah. And of course he found me immediately guilty. And so it was a learning experience. I guess a lot of people at that age don't learn from them. Like, whoa, there's a real problem with taking a legal determination or a legal conclusion like I did and expecting a traffic court judge to actually follow it. And I, John, anybody who's ever gone to traffic court knows if you pull out a court case in traffic court and get them to comply with it, holy crap. Very rarely do they do. They do not care in traffic court. They do not care. That's why I said, if you wanted to see, if we wanted to see these police officers actually get charged, when they're charged, get convicted, don't bring them into a county court, like a superior court or a district court, or, bring them into a traffic court. Their success rate there is over 90%. So they don't give a damn. So yeah, it's legal conclusions or legal determinations or interpretations of law. They don't care. That's why we have to stick with solid issues of fact, even if they don't want to admit that it's an issue of fact.
Yeah, it's true because like when you talk about like the whole anarchist mindset is, I've heard of it from that TV show, but I never knew the definition of anarchy. But like the past couple of weeks, my mind is in a different place now, and I understand that we don't need people to rule over us. We, of course, as a society, we need rules. So yeah, it's all I can say is thank you. And I'm just happy I came across your information.
I appreciate that. And if you ever have any questions or you are going through you're attacked, call the show. We'll walk you. We'll give you all the support we can to help you through that. I would recommend before that, still do the role playing and definitely get in front of a city council and ask the questions. Even again, the first time out, they don't even have to answer it. It may be just enough of a learning experience to just get you up there and ask the questions. And so one of the questions is, look, I know you guys operate under the presumption that if I'm physically in Florida, that your laws apply and give you jurisdiction over me. Do you have any actual evidence, that that's true? And take it from there.
Right.
All right. I'll mute you up. I do appreciate the call. John in South Florida. And we'll move on. And we got another caller, probably last caller of the big broadcast for today. We have area code 907. You're live on the No State Project. What's your name? Where you calling from?
Hey, my name's Cody. I'm calling from Las Vegas.
Was it Cody?
Yeah, Cody.
Las Vegas. What do you have for us today?
Hey, so yeah, I actually got your motion to dismiss. I got a ticket about 2 months ago. No license, registration, insurance, and failure to obstructing a police officer because I didn't give him my ID. And I filed the motion, and I went to my arraignment. I asked her questions, and the judge wasn't having any of it. It just said it's a free trial. And I got a motion hearing on the day of my free trial in the morning.
Well, wait, hold on a second. So the judge didn't hear the motion, forced you to plea. Did he plea for you, or did you enter a plea?
No, he did it without a plea.
He did it without a plea. Oh, okay.
Yeah.
Okay.
And so I was going to be here. You have to sign a paperwork and do all the stuff to be your own attorney. So she was going through the questions for me to be my own attorney. And she just, no, you're not going to be your own attorney. We're just going to set this matter to pre-trial, next week.
He's not letting you. Wait 1 second. Hold on a second. So he's not letting you be your own. He's not letting you defend yourself. Is that what you said?
Yeah.
So they're forcing a public defender on you?
Yeah.
Now, do you already have the motion to dismiss and discover request in?
Yeah.
Well, that's good. Yeah, hopefully they're still going to hear it.
I filed it after arraignment, and they didn't tell me that it was set for a hearing, so I missed the first one, and I had to go back and resubmit it. Now I got it on the 9th of July, and my question is, like, what do I do during the motion session? Or with the motion? I got it here in front of me.
Well, before we start, definitely do some role playing with the script in the No State Project Skype chat. So you get me a Frank Rizzo 3, and we'll put you in there, and then you can start to do that to prep. If you can get to a city council meeting, boy, that's gonna. I can only recommend, but you guys gotta actually do it. I'm sure once people start doing it, they're gonna be like, man, that really, really helped. Getting in front of all those people and asking those questions, going into courts now, much easier now. What you want to do is ask the questions. So if they ask you, if you have anything to add to your motion, don't say no. Just say, has the prosecution submitted sufficient evidence to overcome the motion? Because I don't see it in the record.
Okay.
You want the dialogue to be to be focused on the prosecution's lack of evidence. The motion to dismiss is based on a lack of evidence. They will have to argue that you are incorrect, that they require evidence, or the evidence is on the record already, which now you should know and you should prepare on how to deal with either one of the ways they go about doing that, because they're only going to go one of two ways. Or they could give you,
Mhm.
they could try to really baffle you with BS by saying jurisdiction is a pure issue of law requiring no evidence, period. Oh, except for your physical location, except for that. Okay. I really doubt that, well, the prosecutor tends not to do that. If you've got a Dutch boy, a judge with a Dutch boy haircut, they like to pull that kind of crap. But, and if they do something like that, you have to say objection. Isn't that a contradiction? Either it's a pure issue of law or it's not. If it requires any evidence at all, it's not a pure issue of law. You nitwit. Well, I'm always saying that now. So the other ways that you want to know how to prepare for that. Now, what do you do if the judge says or the prosecutors, we don't have to prove that?
Mm-hmm.
What do you say? Let's walk through the process here. I'm the prosecutor, and I'm saying I don't have to prove that.
I have it here. I would object that I would need the right to clarification.
You remember, we are asking leading questions, so don't leave the door open as long as you can help it for him to give you a narrative. You want to control what he's, as much as you can, what he is going to say. It's just like when they say, sir, I assure you this court has jurisdiction. You say objection. Is that because you said so or because the prosecution's evidence does? You don't open the door by saying you have jurisdiction. How so? Now you open the door for him for a narrative to say whatever the hell he wants. But if you limit it to the only two options that are available to the judge there, then he either answers it's because he said so, or because the prosecution's evidence does, or he just takes the coward way out, which, hey, you do business with a prison system, you're a coward. And he just ignores you and refuses to address the issue, which is very possible.
Yeah.
So if he says that the prosecutor doesn't have to prove that, well, you want to absolutely, objection. Are you saying he can argue the foundation of his case against me and he doesn't have to prove it?
Right.
Yeah, he may say yes. What would you say? Yeah, that's right. That's right. The prosecutor doesn't need evidence to prove the foundation of his case.
And what would I do after that?
I'm going to leave the floor to you, my friend.
Yeah, I'm not sure what I would say.
Okay. Well, and that's fine. That's why we're going through this. What I like to say is, objection. Maybe see if I understand this correctly. The prosecution can argue the foundation of their case against me with no evidence. Do I get to argue against them without evidence?
Okay.
See, it's a nice leading. It's a yes or no question.
Yeah.
Yes or no. What if he could turn around and he may go the other way, and he may say that the prosecution has sufficient evidence on the record to prove jurisdiction. What do you say?
Can I see it?
Yeah, you could say that. I like to back him up a little bit. Oh, he has. So you're saying that there's evidence on the record proving the Constitution and laws apply to me just because I'm physically in Las Vegas or physically in Nevada. Pin him down to that.
Okay.
So then if they'll, it says that you're right here, physically in Vegas, right there. And then, so if they're insisting that your physical location proves the laws apply to you, how do you respond to that crap?
I wouldn't know.
Man, I got to tell you, if somebody from Vegas, you got to have a better BS meter. Again, we're going to assume that is a lie. Remember, just like I talked about all those years ago, it always comes back. The 6 honest men that I keep with me at all times, they taught me everything that I know, tough guy. Their names are who, what, where, when, why, and how. And those last 2 are some of your best friends. So when you're in a situation like this, when they're making a claim like that, You can ask for a clarifying question that's exactly what they mean. Your physical location proves the Constitution applies to you. So if you go to a why or a how question, that will put the burden back on them. And you don't have to feel like, oh, what do I do? Why and how? Remember, those are some of the most powerful questions or effective questions you can ask in these situations. When someone is throwing you a line of crap, the last thing they want to hear from you is how so. So when they say that, you believe that the Constitution, that my physical location proves the Constitution applies to me? Isn't the Constitution a written instrument? How exactly? And you could say, how exactly? Just that's simple. How exactly does my physical location prove the Constitution applies to me and creates obligations? And if you listen to the show and listen to some of the Call of Shames, I have actual prosecutors on the Call of Shames answering that question. And this is what they say. It just does.
And that's not sufficient enough, of course.
I wouldn't think so. Well, I'm just innocent. I'm just not guilty at all. I'm just not guilty. That's the way it works. I just got to say it. To me, it's more like the Bill O'Reilly defense that these people like to use. You may not be familiar. Tie goes in, tie goes out. You can't explain that. Like, you're not familiar with that line?
I'm not.
Wow. All right. Well, maybe you have.
Little youngin here.
Well, well, that's what I figured. You being a youngin that you'd know the meme. All right. Well, but that's what they do. In fact, I want to use the name again as often as I can. Andrew Mora, who is a lawyer with the Franchise Tax Board, a Juris Doctorate, my friend. When he was confronted with that, exactly how does the Constitution apply to me just because I'm physically in California? That's the way it works. That's what he said to me. It's a variation of that. It just does. That's the way it works. That's the way it works. Of course, that's not evidence. Yeah, you could ask, oh, that's just the way it works. So you're going to have a witness testify to that under oath? It's just the way it works. But that's what you can expect. So these are just a little bit of role playing that we've done to kind of get you into that mindset. Who, what, where, when, why, and how. Now, most of the time, what we're focused on is the what. Once we know what the claim is, then we can move to the why and then the how. People will believe, they'll say, well, if you're fit, we've already covered that one. They'll say, well, of course the laws apply to everybody. Really? So you believe that the laws apply to everybody? That's your claim. Yep. Why do you believe that? And you start asking questions to take apart his thought process. What led you to believe X equals Y? And that's all you're trying to do. And we use why and how questions to help bring it out. Now, of course, you can, as you go through the process, depending on how dishonest they are, you're going to want to ask clarifying questions so that you know that you're on the same page, so that they can't accuse you of straw manning. Well, that's not what I said. That's why you'll notice when I write things down when I'm on the phone with you, I'm doing a show with you, and I always write things down when I'm talking to a bureaucrat so that I know I have what they said. It's right there, and I'm not going to take it out of context. And if they try to accuse me of taking it out of context, then any half idiot listening is going to know, oh, he's just being dishonest. He's just being dishonest. Sometimes just reading back or vocalizing their claim is enough to get them to realize how stupid it is. It's just like saying, like it's not a common thing, but one of these alt-right kind of things. So you're telling me, let's see if I understand you correctly. You're telling me that the so-called mass migration into Europe and into the United States is being directed by the Jews to destroy Western civilization. Is that really what you're trying? That's your claim. See, just saying something like that, it's so stupid. It's so unbelievably illogical that Most normal people should start to doubt, oh, so that you don't even have to get to, why do you believe that's true? What possible evidence do you have that the Jews somewhere, some unnamed Jews, are causing and paying for and directing a mass migration to destroy Western civilization? For what end? So that's just, a pretty outlandish example, but I think hopefully you're understanding better now how effective it is to just ask these questions and put the burden on the one making the claim.
Oh yeah.
Yeah.
I've had one situation before this up in 907 Appalachia. That's where I'm from. And, I got a same ticket up there, and arraignment went in. Kind of did the sovereign thing. I'm here under special appearance. I'm answering in the form of a demur, and they dropped the case without even going to pre-trial.
You did the sovereign stuff like that, and they dropped it?
Yeah, I walked in, said I'm here as a special appearance. That's not my name. That's the corporation. And I was waiting. That's what they said. They set it for pre-trial, but then 2 weeks later, I got a letter in the mail saying all cases dismissed.
Well, I get hit with this all the time. It's not always fair. It's not always plausible. But I would say, because the defense that you raised has no merit, it doesn't have any merit standing up for itself out of court. It's completely illogical and unsupported by any evidence whatsoever. I don't think that it was the logic or the effectiveness of the arguments that you raised that led to the dismissal. I can't, again, I know I get that old, and I have to accept for some of the ones that we have thrown out that had nothing to do with the motion. They just were busy and didn't want to be bothered. And I accept that for part of it. And that's why, one of the biggest things is just the fact that you are challenging them in the first place is great. I'm glad I got kicked out. That's fantastic. But
really happy.
I certainly would not use that as inspiration to continue doing that. So you're not going to do that sovereign stuff anymore.
No, I didn't do it here. I had another one where I went in and asked about jurisdiction, like you said, but I saw it on a different video where you asked if it's common law or military tribunal, and they said it's not military tribunal. So I asked if it was common law. He paused for a second and said, no, it's statutory jurisdiction.
Yeah, because it's not 1950 anymore. The statute law has displaced the common law. That doesn't mean that judges still don't make certain determinations that'll hold as the common law, because of course they do that in the federal courts. They look to the state law, but it's all been displaced by statute. It's usually a losing argument. So, but I'm going to try to get one more call. So I appreciate the call and good luck. Let me know how that turns out, and get into the Skype chat, okay, and do some role playing.
All righty, I will. Thank you.
Appreciate it. We got, I don't know what happened, but my other caller dropped off. So I don't know. Well, I'm pretty much completely out of time anyway. And it's always great when anybody stands up to these people. I think whether they're doing it as an activist or because they feel it's an injustice, that even if they just don't want to pay, fight them. Don't make it easy for them. Even if you're going to make a deal, it's all damage control anyway. Even if you're going to make a deal, still fight them. Get some leverage over the prosecutor. Have there be some reason. Let them know that even if you're coming, like even if you did sort of like what he did with this Freeman stuff, I am going to make this so friggin' difficult for you, tough guy. This is going to be tough. That's that they just drop it. Don't make it easy for them. Don't make it easy for them. Because they're not making it easy for us. And that's why, to get back to from what we talked about at the beginning of the show, you've got to prepare. I got to see, I got to see more people going, got to see people going and challenging at the city council meetings. Again, If I was to, one of the other questions is, if I was to do things like your organization, I force strangers to give me money, would you consider me a criminal? And that gets back to what I want to talk about more. I know I've been very harsh about the Free State Project, but again, I was harsh about certain individuals and not painting with a broad brush and saying the whole thing is bad. But maybe, to see more people involved with that, to change. Maybe it could be changing the policy, and that you have the same services, but there is no compulsory payment. Because I don't think we can get away with having things in common, because the last thing I want is big corporations, which would be as bad as government, big corporations running everything. Can you imagine every single road being a toll road? Every road a toll road? No, I don't think that's a solution at all. Some things that, going to have to be commonly held like they are now, but we don't need compulsory payment. We don't need a ruling class to provide it. So again, thank you to Bill and Dan in New Hampshire. Really appreciate the support of the show, and it's great. I do appreciate it. One day I'll get back up to New Hampshire, especially when I saw something the other day about the apple cider donuts. Oy vey, just the sound of that. Oh, maybe. Yeah, I would like to get back there and maybe get a little more active with the people out there with the Free State Project, the anarchist types of the Free State Project. So it's been episode 70 of the No State Project, brought to you by Bill and Dan over there in New Hampshire. I do appreciate that. I will be live on Saturday on the LRN stream, so definitely tune in for that. So if you were not able to get on the big show today, then give us a call on the Saturday broadcast. And remember, government, just a group of men and women forcing us to give them money. They and their apologists actually believe this, that they have a moral right to be immoral, a moral right to be immoral. And as anarchists, we believe that's just that's just not only illogical, but it's criminal in and of itself. But hey, till next time, salud.